Hello and welcome to Psyched, the show where we explore psychedelics through social, economic, and political perspectives. Introduce our next speaker. Next up, we have David Wood. David Wood is a lawyer, patent agent, and partner at Borden Ladner Gervais LLP, Canada's largest national law firm. David is co-chair of BLG's Cannabis Industry Focus Group and practices intellectual property and regulatory law. His regulatory practice is specific to the Canadian cannabis industry and to research and commercialization of psychedelics, entheogens, and entactogens. His intellectual property practice is also largely focused on the technical fields of cannabis, psychedelics, entheogens. Oh, yes, I can't read. David holds a PhD in biochemistry. His graduate level education in structural biochemistry, organic chemistry, physical chemistry, plant biochemistry, and natural products chemistry provides a strong technical background for advising clients in the Canadian cannabis industry and clients positioning for commercialization of psychedelics, entheogens, and entactogens in relation to both intellectual property and regulatory law. David, thank you so much for joining us and welcome to Psyched.
Hello, I'm just getting going here. I'm not sure if you can hear me or if there's an echo.
We can hear you well. We cannot see you though.
Okay. Just give me one moment. I think I've got it. There we go. Can you see me now?
Yep, you're good.
And now I'm going to share my presentation. There we go.
Yep, you're good. We can see it.
Just let me go into slideshow mode and we'll get into it. I would like, it seems to be sharing the wrong screen. Just a second, I know what I'm doing here. Come on. Okay, just a moment. Just bear with me. Hope everyone's doing good this morning. That was a good panel on diversity. Or presentation, I should say. I'm really sorry about this. I seem to be able to share my presentation screen, but not my not the PowerPoint part that I want to. Just give me one more moment here. There we go. All right. Oh, I ruined the surprise. All right. Now we're starting, and I will make sure I'm unmuted. There we go. So,
actually, David, now we're getting a bit of an echo. If you could unmute.
I think now we're good. I think now we're good. Sorry about that. So yes, thank you for the introduction. Very happy to be here. Very happy to be talking about this important topic. at psyched this year. This is fantastic. So I was already introduced. Thank you very much. We tend to just have a quick slide about the presenter. So since we already went through that, I will skip that slide and get into the mood a bit with, all right. So this presentation, as with any presentation you're going to hear from lawyers, is informational only. It is not legal advice. I thought a lot about how to present this to a broad audience because there's a lot happening up here in Canada, just like there's a lot happening globally. So I thought I'd take a bit of a Canadian focus and talk about the legal status of psychedelics in Canada to start with, and then give a little more context that relates to what I'm helping clients with. And that's, I mean, right now, everything that's happening in psychedelics has to relate somehow to the traditional pharmaceutical system. So we're going to talk a bit about drug product regulatory approvals and patent applications and how those work together. So that's all the context. And then once we've gotten through that context, we'll get into some consideration of how psychedelics break the mold on this model and whether there is room for access outside of pharmaceuticals and how human rights in Canada interface with that and what we can, expect, what we know we'll see and what we might see. And it's all very exciting. And a little quick note on jargon. Just to keep it simple, I'm going to use the word psychedelics. It's the most recognizable. It's the easiest. I am using it as an umbrella term. So the legal status of psychedelics in Canada. This will not surprise you. I'm going to start, though, with the idea that psychedelics are not illegal. Murder is illegal. Theft is illegal. Those are activities that are prohibited in all cases. Psychedelics are, however, controlled substances. And like with any any regulated material, a controlled substance is subject to prohibitions and authorizations. The same is true, again, of any regulated product or substance in Canada. And we'll get into a couple other examples later when we're talking about models that might work for this going forward. So, like the United States, Canada is a party to the 1961 UN Convention, which means we need a Controlled Drugs and Substances Act, which was most recently revamped in the 90s. And as an important note for our American listeners, criminal law and controlled drugs and substances law in Canada is not like in the United States. It is entirely federal. And Canadian provinces and municipalities have no authority to soften these prohibitions or to broaden authorizations. So you're not going to see individual cities in Canada following Oakland, Denver, and Santa Cruz's lead. So just to give the context very quickly, just like the United States, we have several schedules. Possession of a substance listed in schedules 1, 2, or 3 is prohibited unless authorized. Schedule 1 includes MDMA and ketamine. Schedule 3 includes most of your other psychedelics. The Schedule 1 does not mean the same thing in Canada that it does in the United States. In fact, most, not MDMA, ketamine is, most Schedule 1 substances, other than a lot of amphetamine analogs, are prescribable. It's Schedule 3 has a lot of the substances that have known recognized medical use in Canada. So it is a little different, but largely semantics. So that's the prohibition. In terms of an authorization, it is possible to get a dealer's license in Canada to work with controlled substances. There's 2 different kinds of controlled substances we'll focus on. One is narcotics, which would include ketamine, and the other one is restricted drugs, where most of my clients are focusing, which is your traditional psychedelics, as well as MDMA and the 2C phenethylamines. Dealer's licenses are available under the narcotic control regulations and under Part J of the Food and Drug Regulations. The primary difference between them is that narcotics are prescribable. They have a recognized medical use, and these licenses are often commercial manufacturing licenses. So if you're a drug company and you're selling opiate painkillers, you would have a narcotic control regulations license, and you'd also have a dealer's license to help you, drug establishment license for commercial production. FDRJ dealer's license allows production and work with restricted drugs. These have no recognized use, so all of this work will be research, and a lot of it will be clinical trials. This is basically a reiteration of what I just said. Again, narcotics, medical use; restricted drugs, no medical use. Psychedelics other than ketamine, if you consider that a psychedelic, are all restricted drugs today in Canada. If one of them gets a DIN, which we'll talk to in a minute, then it would presumably be moved to the narcotic control regulation schedule instead of the restricted drug schedule. Lastly, and you probably see this in some investor decks and people talking about this, in addition to a dealer's license, it is possible to get an exemption directly under the Controlled Drugs and Substances Act for a limited purpose to work with a controlled substance. And those will be very narrow in scope. Typically, they'll be issued for a specific supplier and for a specific purpose, and there will be really specific requirements on how disposal works after, and paperwork, and how you work with Health Canada. The dealer's license is a harder thing to get, and they trust the people holding it a little more, so there's a lot more freedom in what you do if you're a dealer as opposed to an exemption holder. And we'll get back to this exemption holder point at the end of the presentation. So very briefly, I'm not intending to give a detailed talk on pharmaceutical regulations, but for the points I want to make, it is important to give some context around this. So, and I've chosen MDMA for the drug product regulatory approval slides because, as we all know, it's going to be the first one. Congratulations, MAPS, when it happens. We're all hopeful that it's successful soon. So in Canada, a drug is defined as something that is, this is important, manufactured, sold, or represented for use in, and then I've highlighted a couple things there, basically in correcting a problem or restoring organic function. So they're therapeutics, and we'll come back to this with a couple other classes of products towards the end of the presentation. So once a drug in Canada cannot be sold without a regulatory approval, much like every country, that's regulated under Part C of the Food and Drug Regulations. And when a drug's ready to be sold, it will have a drug identification number, or DIN. A DIN is a product level regulatory approval. And as with anywhere in the world, and Canada's DINs will be recognized in many other countries, just like we recognize the equivalent approvals here. To get that, you require a clinical trial, which must be approved by Health Canada before beginning. And a clinical trial will require a lot of test subjects, a sponsor, which you can think of as the company that's going to commercialize the drug. And it also requires a primary investigator who will have to comply with ethics review. And as we all know, a significant amount of time and money. So once a clinical trial is completed, something called a notice of compliance will issue to the manufacturer, and a DIN will issue to the sponsor. A DIN is the product level authorization. A notice of compliance is a manufacturer level authorization. So once a drug product has a DIN, it can be manufactured by any entity holding a notice of compliance. And if an entity holds a notice of compliance, or sorry, if there is a DIN out there and a second company wants to commercialize the drug, then that second company can, under some circumstances, take advantage of the regulatory approval of the first company. And this is very important for psychedelics. And once we talk about patents a little bit, it'll become more apparent why. Once a drug is approved, a particular active pharmaceutical ingredient, a particular API is approved for the first time in a drug, the drug will be considered an innovative drug, which means it has data exclusivity. Now, an innovative drug doesn't have to be patentable, and it doesn't have to be a new substance. It just has to be approved as a drug for the first time. And the Canadian Food and Drug Regulations prohibit the manufacturer rather from filing for a notice of compliance for the first 6 years that an innovative drug is on the market. The Food and Drug Regulations also prohibit it from being issued until 8 years from the date the drug first hit the market. So again, what I'm saying here is that once, say, MDMA or psilocybin is approved as a drug for the first time in Canada, it will be 6 years before Health Canada will allow another entrant to use the same regulatory filings as the first one. Other people can file for different indications on different data, that's fine, but they can't take advantage of the work that's already been invested by the first one to be approved, not for 6 years. And this is very important for people commercializing psychedelics because of how the patent system works. So just patent 101, a patent is a statutory agreement with the state. Those words are very carefully thought out. When you have a patent, it's an agreement between you and the government of the country the patent's issued in. So what that means is you're giving away something, just like if you agree to buy someone's car, you give them valuable money, they give you a valuable car, you're both happy. In this case, an applicant gives a valuable disclosure of their technology so that they don't keep it secret to the government. The government will publish that application, and to the extent the subject matter is novel and inventive and useful, that person will get a monopoly, a time-limited monopoly. So that monopoly, by the way, is 20 years. So once you file a patent application, the patent office will review it, and to the extent they consider it the subject matter of your claims to be novel, inventive, and useful, you will get a 20-year monopoly on those claims. What can you claim? Well, you can claim, it's right there, any new and useful art, process, machine, manufacture, or composition of matter. So a composition of matter is going to be the gold standard for a pharmaceutical company, including anyone commercializing psychedelics. But to get a composition of matter claim where you have a monopoly on the substance itself, then the substance must be new, inventive, and useful. So clearly you can't patent LSD or MDMA or mescaline, which we have right there, because those substances are well known, they're not new. And if you had a composition of matter claim, you could prevent competitors from manufacturing the substance for any purpose. If you have a patent on, a new compound, people can't use it for the same clinical application you're using it for. They also can't use it as a paperweight. It's just off limits. And just on semantics, methods of medical treatment per se are not patentable in Canada, but in an example of legal rules that are very hard for most people to relate to, use of a compound for treatment of a condition is fine. So you see this a lot where use of previously known compound in the treatment of, and I'll go back to MAPS. An easy example is MDMA for PTSD. That, I don't know if they filed patent applications. I don't believe they have, but that at some point might have been patentable. Also, if you have a new use for an old compound, that is vulnerable to off-label use. That's what off-label use means. It means that while a drug may be approved for one indication, it's being prescribed by physicians willing to take the moderate amount of risk involved off-label for other conditions. One example of that would be prescription of racemic ketamine for depression. That is off-label use. S-ketamine is approved for depression, but not race mixture ketamine. So that technically is off-label use. A method of manufacturing a compound may also be patentable, but that has limited effectiveness in protecting a drug product if someone else can get regulatory approval for the same indication and the same substance. So, and I think some of you can probably see where I'm going with all this, but psychedelics really break the mold on this business plan, because when you're commercializing a novel API, you file patent applications to the composition of matter, you protect any formulation with your API in it for 20 years, which gives pharmaceutical companies a lot of time to recoup the significant cost of bringing drug products to market. It also helps them recoup costs of failed clinical trials, because again, they have a monopoly and, you know, as long as they get one broadly marketable, you know, blockbuster drug every so often, then the math makes sense. But with psychedelics, you can't do this because, as in the slide, at least 3 compounds, MDMA, psilocybin, and LSD, are likely to be therapeutically useful. And any patents on LSD expired decades ago. MDMA, not sure if it was ever patented, but it was invented even earlier. And psilocybin in pure form was extracted and synthesized in the 50s as well. So these aren't patentable by themselves. Maybe you could patent a formulation or a way of building a capsule, but it makes it a less attractive proposition, you know, for companies that are used to giant markets, you know, to commercialize these. The data exclusivity I mentioned earlier will apply for whoever's first to market, but once there's 2 people in the market, that data exclusivity isn't going to give a lot of value to anyone because of off-label use. So if company A gets psilocybin for treatment-resistant depression and company B gets psilocybin for a different indication, the minute company B's in the market, the monopoly company A enjoyed is gone, and they don't have 20 years like they would with a patent. At least they won't in terms of off-label use creeping in. Perhaps doctors, especially in a new area, will be less willing to go with off-label use, but you know, time will tell, and that'll be determined largely by education. Another reason psychedelics break the mold, and this might not apply to microdosing, but for therapies that involve flood dosing, you're talking about something that people aren't going to do very often, and you're talking about psychiatrists eating a lot of the psychiatrists and psychologists taking up a lot of the value chain. So when someone has a prescription for a psychedelic and they're going to go get therapy, most of the money they spend will be on therapy. And that brings us to what I think is the most interesting part of this talk. There was a lot of build up to get here, and I hope the context helps, but that's access outside of pharmaceuticals. We know for sure that we're going to see psychedelics as pharmaceuticals. It's going to happen. But what if we did something else? I brought up the natural health product definition here. Ironically put next to 2CB, nothing natural about that. So natural health products, you'll see some consistency with the definition of drug here. They have to be sold for correcting a disorder. Natural health products also have to be natural. They have to be from plants, algae, etc. Certain vitamins are specifically included just to make them easy to purchase. Natural health products specifically exclude controlled substances and cannabis. Like drugs, you need a product-specific approval called a natural product number, and it requires safety and efficacy data, but to a much lower standard than for drug products. And NHPs, as everyone knows, can be purchased without physician approval. Another regulated product class at the federal level in Canada is cannabis. Cannabis is its own thing. And this is what the regulations on cannabis look like. These are regulations for one substance. One substance you can smoke, eat, vape, rub on your skin, might be psychoactive, might not be, might be hemp-derived, doesn't matter. It's all cannabis in Canada. You can get medical access to cannabis, not through a prescription, it's a different type of access, but it's largely self-directed. In fact, cannabis products it is prohibited to give any sort of indication on the product itself as to what it might be good for. Once you have medical access, it's not like you look at a bottle and say, oh, this one's for pain, this one's for sleep. That's up to you to figure out. And the companies who sell those products, again, regulated uniformly across the country, they are not allowed to hold out in any way that cannabis might help you with a medical problem. So this is an interesting disconnect because you have a medical product that you can buy medically once your doctor authorizes, or you can just go to an adult use store and take care of it yourself there. Okay, it looks like we're at the end. I'll just, if you'll bear with me just for a couple more minutes, I want to just make one point here. Just a moment. So medical cannabis began because someone was successful challenging the law. The prohibition on cannabis, the wholesale prohibition, was unconstitutional. That challenge resulted in the adult use market we have today. Many of the same arguments could apply to psilocybin fungi. And I think there's room there for access outside of the pharmaceutical system. There's currently Section 56 exemption was applied for by a psychotherapist called Dr. Tobin. He was denied, and that is being appealed. This was in the news recently. This could lead to psilocybin being regulated for medical purposes in much the same way that cannabis was until 2018 and remains now in the broader adult use market, also regulated for medical purposes. So this, and they're also now, by the way, talking about how cannabis health products that would be for an indication would have health benefits on the bottle. Canada's kind of figuring that out. So by combining, I think we're heading to a bit of a perfect storm here, because we've got a lot of support for cannabis or health products. We've got a lot of support for regulatory reform around psilocybin. And we've got this system where we have NHPs, which are self-directed medicine, not impairing, have to have safety data. You've got cannabis products, also can be purchased medically, no safety and efficacy data whatsoever, although big anecdotal safety data, and they are typically impairing. You're going to have cannabis health products that are probably going to be both. This, again, if you consider that our charter may require access, at least to psilocybin, kind of opens the door to potential descheduling of some restrictive drugs and maybe regulation of them in a similar way to cannabis. Again, Canada has practice. We did this for cannabis. Maybe we can do something similar for psychedelics. And as a last point, maybe even outside of medical access, maybe there'd be some room for psychedelics to be regulated in a way where adults can simply purchase them or pay to take them somewhere safely and informedly. And I hope that we all work towards making that happen. You know, people working in the industry in Canada and people who are maybe not working in it, but sympathetic to it. Like, I think change is happening. And I think we're very fortunate to be focused on this topic at this time. I ran out of time. My apologies for that. This is the questions slide. Thank you all very much for listening.
Hey, David, thank you so much. Really appreciate it. Just to kick it off, was really hoping to hear your perspectives on the differences between US and Canada in terms of, I guess, timeline and costs of taking a drug through the FDA process. So it would be a different agency in Canada, but was hoping you could make a comparison between the two. Is it more difficult if you're working in Canada? Is it easier? I think a lot of people have had that question.
I will have to get back to you on that. That is unfortunately something I don't have a lot of visibility on today, because generally the clients I'm working with, to the extent they are already engaging in that process, or looking at, you know, a lot of times the discussion on this stage, on phase 3 and beyond, is in most cases going to have to happen by an acquirer. I mean, again, look at MAPS and their, you know, how long they've been trying based on donations. So I really can't comment on that. But what I will say is that there's a lot of treaties that establish uniformity. So I would expect that a lot of the costs would be similar, but I don't have a lot of visibility on that. My apologies.
No worries. The other question that I would love to get your insights on is, you know, you've talked to companies in the space, possible investors in the space, and have looked at least a little bit into IP, understand how it functions. What would you say is, you know, the strength of IP portfolios in the space, given that it seems like some entrepreneurs, some companies don't necessarily have the awareness that you do of, you know, psilocybin, MDMA, LSD kind of being open for many years now, and folks trying to patent around them. Are the patent portfolios of the average company in this space pretty strong? Do we see a future for them, or are they, more kind of holding up the company in more of an optics focused way, allowing for them to get to the next stage, but don't really hold too much value or substance in the meantime?
I have seen both, and the sample size is too small to establish a normal. I know one approach that I think holds a lot of promise is when you take a compound, and I think with most examples we see it's going to be psilocybin, and then make an informed theory and hypothesis-based choice on what to mix that with. Like I've seen some very promising work where psilocybin is being combined with generally regarded as safe grass materials that you might see in natural health products. And it's being done, like the grass materials that are being put in with the psilocybin have been chosen rationally. And I think we're going to see some interesting data soon working with that client on what the effect of those mixtures are at a tissue culture level. And so I've seen both. And I think the ones, I really like the idea of formulations that include a psychedelic and another compound. And in that particular company's case, they're very focused on getting benefits at low doses, at minimally effective doses, which can be good because it's going to be easier for a regulator to get on board with something that's not going to be heavily impairing. And that was a point that was actually made in the slides. It's just one I glossed over a bit. So thank you for asking that.
Beautiful. Well, David, we are out of time, but thank you so much for coming on and sharing your insights and perspectives with us.
Thank you. Had a great time doing it. Have a good day.
Yeah, you too. Bye-bye.